So, ladies and gentlemen, it is my great pleasure to welcome you for this second day of our conference when we are going to tackle the law of the sea. I won't be long, just two things. Last week we had the great pleasure to have a smaller event, but it was nevertheless very interesting, which was a kind of a conversation around the book edited by Alexander Prof, the commentary of ITLOS. And Beck is kind enough to be present today at the conference, so just for you to know that you can buy the book with a discount or order it. And I can tell you it's really worth. And if you're interested with the conversation that Alexander Prost had with Alina Miron last week, it will be put on our YouTube channel, so you can have an insight in the making of the book. Besides this, several of you came to me or to other organizers just wondering why we had decided to gather in one conference fresh water and salted water. My first answer was that we thought that it would be good that the two communities working in this field meet and have exchanges, but they somehow remarked accurately that we had separated speeches, although we can feel from the question that some connections have already been made. But we thought that it would be good that Marco and Tama, who were the initiators of this conference, say a few words to explain the rationale of the conference. So I give them the floor for a very few minutes before the first panel. Thank you.
Thank you very much, Professor Ruiz-Fabry, for giving us the opportunity to say a few words about the raison d'être of this conference. So, at first glance, you might wonder, what is it that binds the law of international watercourses and the law of the sea, other than water? After all, these are two disparate fields of international law with rules and principles that are quite distinct. But even there, we notice there are some interesting connections to be made. For instance, if we look at the ILC draft articles that culminated in the 1997 New York Convention, you'll see that the special rapporteur actually sought inspiration from the UN Convention on the Law of the Sea. And I refer here to the article relating to the protection and preservation of ecosystems. They drew a parallel with a protection of the marine environment in UNCLOS. And the other way around, this is also true. If we look at UNCLOS, you'll see several references to rivers, such as anadromous fish stocks, so the fish that are born in the rivers and swim to the oceans, or, for instance, the origins of land source pollution, because pollution can also come from rivers and estuaries. But it's not because of the substance that we wanted to bring together these two bodies. The main reason that we wanted to do it is because we're at an interesting juncture in history when it comes to the development of these two fields. And we would describe these as opportunities and challenges. So if we look to start off with the law of international watercourses, ever since the adoption in 1997 of the New York Convention, there's been some great debates concerning the content of the principles of international watercourses law. And I think that yesterday you got to see that these debates are still quite lively. But this is also a moment of opportunity. Currently, as you heard, there is a case pending before the International Court of Justice between Bolivia and Chile, and the court might address very important principles of international watercourses law. When we turn to the law of the sea, there have been great opportunities ever since its entry into force. So for the past 2 decades or so, there's been a proliferation of international cases, be it before the ITLOS or arbitral tribunals under Annex VII. But there are also challenges here, and I would reference, for instance, the recent instances of non-participation in the Arctic Sunrise case between the Netherlands and Russia, and the South China Sea arbitration between the Philippines and the People's Republic of China. So there are interesting connections there. But we also believe there are commonalities at a more technical, concrete level. And we were very happy to see that there was a lively debate yesterday by Judge Tomka, by Judith Levine, on site visits. So if we look at site visits, we'll see that the best examples, perhaps, are to be found in cases dealing with international watercourses and with the law of the sea. We can go back to the predecessor of the ICJ, the Permanent Court of International Justice, its case concerning the Meuse, between the Netherlands and Belgium, where a site visit was organized for the members of the bench, and they got to see the locks and the installations, and they got technical explanations of how it worked. And now the more recent examples are often provided in law of the sea cases, such as the Bay of Bengal arbitration, or for instance, the recent site visit in the maritime delimitation concerning the Caribbean Sea and the Pacific Ocean. So we hope that during the course of the present day, we'll be able to identify more commonalities and interesting comparisons. And with that said, I would like to give the floor to Professor Alfred Sohns. Thank you very much.
I'll speak from here. Ladies and gentlemen, good morning. I was going to say welcome to this first panel of the second day, but it almost looked like we would be having another first panel, but there was only one speaker rather than two. But thank you very much for that introduction about the scope and the whole idea behind the conference as a whole. I was going to say anyway that after a very rich day yesterday, we will now turn from freshwater disputes to saltwater disputes. As we all know, under the Law of the Sea Convention, with now 167 state parties and also the European Union as a party, in Part 15, there is an elaborate arrangement for the compulsory settlement of disputes relating to the interpretation and application of the Convention, with a series of general exceptions and optional exceptions. According to many, this was a major achievement of the Third UN Conference on the Law of the Sea. Some are less enthusiastic. This arrangement will, I believe, also be addressed in later panels today, but in this panel, we will concentrate on issues of procedural law. We have 3 speakers, each 20 minutes maximum, so that we have ample time for discussion. And I hope that we will have about 6-7 more minutes, which will be deducted from the coffee break after this wonderful introduction by you. These 3 speakers are all eminently qualified for this panel. They bring to the panel a wealth of experience with the matters to be addressed, in particular as counsel to parties in cases before the 3 institutions dealing with law of the sea disputes, the International Court of Justice, the International Tribunal for Law of the Sea, and ad hoc arbitral tribunals under Annex VII of the Law of the Sea Convention, supported by the Permanent Court of Arbitration in practice. You have their short bios in the conference folder, so they need no further introduction. The first speaker, according to the program, we will follow the order as announced in the program, is Professor Marcelo Kohen of the Graduate Institute in Geneva, who will guide us on this transition from fresh to salt water. So he will be traversing brackish water as well. And contrary to what is said on the program, I understand that he will speak on a number of issues which are common to both freshwater disputes and law of the sea disputes, including the specific topic announced in the program of diplomatic means as a requirement, a prerequisite, for the exercise of jurisdiction. So the topic will be dealt with, but after some other topics to be mentioned by him first. The second speaker, then, according to the program, as you have seen, Mr. Lawrence Martin, practicing lawyer at Foley, Hoag in Washington, D.C., on fact-finding and evidence in law of the sea adjudication. And then the third, Sir Michael Wood of 20 Essex Street, third-party intervention in interstate arbitration. So I'll now give the floor immediately to Marcelo Kohen.
I have to thank the organizers, Eden, Marco, and all of them. I would say twice. First, because of the invitation to participate in this important conference, but secondly, because they accepted a change in the content of my presentation. Indeed, you came here this morning to start discussing about the law of the sea, but I will still keep some issues concerning fresh water. So I would like to I will take advantage of the fact that I am the first speaker of this first panel, and as Fred said, I will try to make a bridge between the two important areas of international law we are discussing here. And the first point could be maybe whether there are common specificities of disputes concerning international water courses and law of the sea disputes. And I think that there are some. First, in general, these kind of disputes refer to ongoing situations. Second point, they may concern uses of both water courses or maritime areas in different fields, for instance, in navigation, but also in the field of natural resources. And of course, questions concerning environmental transboundary harm. They may also be related to the determination of boundaries, but here an important difference must be mentioned, the fact that water courses boundaries are governed by the rules concerning land boundaries, whereas maritime areas are governed by different rules, as we all know, with the probable exception of internal waters if one follows the arbitral award in Croatia, Slovenia. I'm saying this under the control of some of the arbitrators here. Sometimes the maritime delimitations disputes are coupled with a dispute concerning the mouth of a river and the starting point, as Judge Tomka mentioned yesterday. So this is another point in which one can find some common points. And another important point in common could be the fact that the absence of an agreed delimitation may raise similar problems. That is to say, activities carried out by both states in contested areas. So these points in common may also provoke common practices in procedural matters or some specificities. I will try to mention very briefly, of course, be sure, questions concerning jurisdiction, questions concerning admissibility, counterclaims, joinder of cases, provisional measures. Let me try to briefly mention some of these points. Questions concerning jurisdiction. In both areas, there may be problems concerning whether certain aspects of the disputes fall within the realm or within the jurisdiction accepted by the parties. For instance, in the field of international waterways, in the pulp mills case, the question was whether pollution other than that related to the quality of the waters of the river Uruguay could fall within the jurisdiction of the court. I remember you that this case came to the court because of the existence of a compromissory clause in the treaty, the Statute of the River Uruguay. In the case of disputes concerning ITLOS, whether territorial sovereignty matters can be discussed by arbitral tribunals. Obviously, I have in mind the Chagos Marine Protected Area case and the South China Sea case. Very recently, last Saturday, a chamber of ITLOS in Ghana, Côte d'Ivoire, discussed the question whether matters concerning international responsibility are included within the jurisdiction of a tribunal dealing with a dispute concerning ITLOS. And also, the question whether internal waters fall within the realm of the UNCLOS. That was a question that was raised in the Ara Libertad case. And I'm sure that most of you believe that this is not the case. Internal waters are not governed by the UNCLOS. I think otherwise, and if you want to know what I think about this, you can read my contribution to the Festschrift for Judge Hugo Caminos. Questions concerning admissibility of claims. I would like to refer to what the court said in navigational and related rights, one of the numerous Costa Rica versus Nicaragua cases. So Costa Rica raised a new claim in its memorial, a claim that was not mentioned in the application. And Nicaragua raised a very late objection to this claim on the basis of its inadmissibility. And as you know, there must be cases in which late claims may be raised and can be considered admissible if there is a close connection with the application. And what is interesting here is to mention what was the reason the court invoked to accept, to consider that this claim, it was the claim concerning fishing rights by the riparians of the Costa Rican bank of the San Juan River. And the court considered this late claim admissible, I quote, given the relationship between the riparians and the river. That was the reason why the claim was considered admissible. Then we have some experiences of joinder of cases, both in the law of the sea and in disputes concerning international waterways. The well-known cases on the North Sea continental shelf, that it was a delimitation involving 3 riparians of the North Sea. And in the field of international waterways, also numerous Costa Rica, Nicaragua, Costa Rica cases. So certain activities carried out by Nicaragua in the border area and construction of a road by Costa Rica along the San Juan River, and very recently the maritime delimitation case and the land boundary in the northern part of Isla Portillos, which also involves questions concerning international waterways. Counterclaims. That's interesting also, because in both areas you may have the parties having competing claims or similar claims against each other. So Nicaragua, in the certain activities case, raised counterclaims in its counter memorial. One of them was identical to the claim made through the institution of different proceedings. I will not discuss the issue here, but it is interesting to mention, for instance, the pulp mills case, in which there was not such a situation. Uruguay requested provisional measures concerning some problems created by Argentine citizens in the bridge across the river Uruguay, but there was not an issue about instituting counterclaims for that. Then we have the problems of provisional measures. And here we also have many points in common. If we have a look at the practice, we will see that in many cases, both law of the sea or international waterways, the state requesting provisional measures invoke the risk that the other party is seeking to impose a fait accompli. That was the case of Malaysia in the land reclamation case. That was the case of Finland in the passage through the Great Belt. That was also the case, if I'm not mistaken, by Côte d'Ivoire in Ghana, Côte d'Ivoire. And it was also the case concerning waterways of Argentina in the pulp mills case. Another point in common is the difficulty to prove the existence of a risk of irreparable prejudice, particularly in cases concerning transboundary environmental harm. And this is also a point in common, because if that was the problem Argentina faced in pulp mills, Costa Rica in certain activities, Nicaragua in construction of a road, Malaysia in land reclamation. Also the problem of urgency. This is, if you have a look at the cases of the passage through the Great Belt or pulp mills, whether the construction of a bridge or the construction of mills met the requirement of urgency, because you need time for constructing a bridge, you need time for the operation of a mill, and the question arises whether when the state coming to the court or the tribunal requesting provisional measures is in a situation of urgency or not. Obviously, these kind of difficulties, both for risk of irreparable prejudice or urgency, these kind of difficulties do not appear when the other party invaded the territory of its neighbor and constructed artificial channels in a wetland of international importance. And this is the reason why, for instance, Costa Rica did not have any difficulty in obtaining provisional measures in the case against Nicaragua. There is another problem concerning provisional measures, which is the situation in which a party requests as provisional measure exactly the same thing or something that resembles at least what it requires for the merits. This was the case, I would say, by Argentina in the Ara Libertad case, and also the request made by Nicaragua in construction of a road, because Nicaragua requested that as provisional measure that Costa Rica should immediately provide with an environmental impact assessment, exactly the same Nicaragua requested for the merits of the case, and this would have prejudged, obviously, the case. The difference is that Argentina got what it wanted by way of provisional measures, and Nicaragua did not. Obviously, in the field of the law of the sea, there are some specificities with regard to provisional measures that do not appear in international waterways disputes, which is the possibility by ITLOS to decide on provisional measures in a case that will be decided by another tribunal. And this raises a particular problem with regard to the analysis of the prima facie jurisdiction. I have in mind the Mox and the Southern Bluefin cases. But let me say, at least, let me give my feeling. I have the impression that it is easier to obtain provisional measures before ITLOS than before the International Court of Justice. And now I come to the very topic I was requested to speak in the program, which is diplomatic means as a requirement for the exercise of jurisdiction. Mr. Chairman, how?
Yeah, 4.5 minutes.
4.5. Okay. Thank you very much. So, we all know the requirement of Article 283 of the UNCLOS concerning the obligation to exchange views, but we also have similar requirements in bilateral treaties concerning international waterways, and I will refer, if I have time, to the Statute of the River Uruguay and the Port Mills case, if I have time. So what is important to notice here is that the obligation to exchange views is not an obligation to exhaust diplomatic means. This is quite clear from the case law, from the very Article 283 of the UNCLOS. What is also important is the manner in which the tribunals, I would say, come to the conclusion that this condition has been met. If I quote land reclamation, also Luisa, it is mentioned by the ITLOS that Article 283 of the Convention only requires an expeditious exchange of views regarding the settlement of the dispute by negotiation or other peaceful means. And what it was mentioned in MOX and also in land reclamation, a state party is not obliged to continue with an exchange of views when it concludes that the possibilities of reaching agreement have been exhausted. That is to say, it is just for one of the parties to the dispute to consider that exchange of views were enough, and then the party concerned can go to the ITLOS or to an arbitral tribunal, etc., etc. But sometimes there is urgency in the preparation of the case, and I have in mind the Ara Libertad case, and we have to meet the requirement of exchange of views. And what is the problem if the other side doesn't respond? For instance, if you send a note and there is no answer, can you consider that this has exhausted the exchange of views or not? Argentina took a wise policy, which was to send the Vice Minister of Foreign Affairs to Accra, the capital of Ghana, and that was enough, according to Argentina, to meet the obligation of exchange of views. Then you have, but I don't have time, I realize that I don't have time to discuss compromissory clauses which explicitly require the exhaustion of negotiations or any other diplomatic means, or fixing time limits, after which you can go to arbitration or to the ICJ. What I would say, because I don't have time, is that there is no general international rule imposing parties willing to go to a court or tribunal, if there is jurisdiction, imposing the exhaustion of diplomatic means before going to the court or the tribunals. And this is what the court mentioned, in particular in the Cameroon versus Nigeria case. To conclude, what is the importance of the exchange of views required by the UNCLOS? I think this is a wise provision because it is important to at least try to determine the existence and the scope of the dispute, to convince at least one of the parties that negotiations will be meaningless, to attempt at reaching agreement as to the means of dispute, of settlement to be followed. Because another point which should deserve more analysis, not here probably, is the scope of Article 282 of the UNCLOS compared with the entire system. I don't have time to discuss this. But what is the problem? So this is, I mentioned the importance of the exchange of views, but what is the problem when you have compromissory clauses in which there is no reference to time limits to negotiations, and negotiations is a condition? The problem is that the party which is not willing to go to the court or to the tribunal, or even worse, is not willing to settle the dispute at all, so may use negotiations as a manner to prolong the dispute in an indefinitely manner. So, I just conclude with this, and I thank and I congratulate the organizers for having given us the opportunity to think about the points in common and the differences of procedural issues in these two important areas of international law. Thank you.
Thank you very much for this very broad survey of a whole list of issues. But you made a number of intriguing comments, including the one that provisional measures may be easier before ITLOS than before the ICJ, so maybe that's one topic for a later discussion. But let's now move immediately to the second speaker, Mr. Lawrence Martin.
Thank you, Professor Soons. Can everybody hear me? Is this working okay? Great. With the chair's permission, I'm going to remain seated for my presentation so that I can see my own slides and know what I'm supposed to be saying to folks as I go through this. I've been asked to address questions of evidence in law of the sea disputes. To try and do this in 20 minutes, frankly, is a bit of a challenge. As many know, including Marco, this is a topic on which one could probably devote a seminar unto itself. So I thought I would focus on a couple of areas that I find interesting and useful, and I hope you will too. And I thought I would examine them all through the prism of a particular dispute, in particular the South China Sea arbitration. And I do this very self-consciously, mindful of the fact that I have one of the arbitrators sitting next to me. I have a number of my co-counsel in the audience. So any mistakes and gaffes that I make are entirely my own. The three subject areas that I thought I would touch upon are questions of evidence and proof that are complicated when a state chooses not to appear in a proceeding, as China chose not to appear in the South China Sea arbitration. Questions, methods of proof. How do you go about proving your claims? And for this purpose, I'll focus on what was probably the Philippines' central claim, that is China's claim to historic rights throughout the areas of the South China Sea encompassed by the 9-dash line. Excuse me. And then finally, I'll pause upon questions of experts in the way in which experts are used in state versus state proceedings, and interesting approach that the tribunal adopted in the South China Sea case. So I'll turn first to the question of non-appearance. And the proceeding was conducted under Annex VII of the Law of the Sea Convention, Article 9 of which is on the screen now before you. This, of course, is an echo of similar provisions that are in the rules of the ICJ, the rules of ITLOS, and contemplate a situation in which a party fails to appear, and in that situation allows for proceedings to continue, but places on the tribunal or the court a very substantial burden to determine for itself that the claim is well-founded both in fact and law. And in thinking about this burden, I think it's just useful very briefly to recall that the predicate of a state versus state adversarial system is you have two sides. One state puts forward its case. It puts its best foot forward. The other state appears. It puts its best foot forward, and there's trust that in the competition of ideas, the truth, or something close to it, will fall out in the battle of ideas. But of course, when a state doesn't appear, that predicate of the system it doesn't apply, it's undermined, and therefore the burden is placed very much on the tribunal to, in effect, take the role in part of the party that fails to appear. And it's very interesting because in domestic legal systems, including in the US legal system, when a party fails to appear, the conventional remedy, of course, is a default judgment. You win automatically. But that can't and doesn't happen in the international system. The tribunal, I should say, took very, very seriously the obligation to satisfy itself that the claims of the Philippines were well-founded in fact and law. On the screen right now is just a quick review of a part of the procedural history The Philippines presented its memorial in March 2014. And although China had made clear that it had no intention of participating at any point in time, the tribunal made every effort to leave open the door for the possibility of it appearing. It therefore scheduled a due date of 15 December 2014 for China's counter-memorial. Of course, it was a surprise to nobody when China did not submit its memorial, including the tribunal, as attested by the fact that the very next day, after China did not submit its memorial, the tribunal presented us, on behalf of the Philippines, with a list of 26 different questions on which they wanted additional submissions from the Philippines. And they wanted them rather promptly, if I might say. As you see, we had all of 4 months to prepare our responses to these questions. As I said, there were 26 questions, not including subparts, of which there were many subparts. They were roughly divided about 50% between jurisdiction and the merits. And you can see, just by way of example, one of the questions, one of the issues that the Philippines had put in dispute was the status of certain features in the South China Sea. Were they low tide elevations? Were they rocks? Were they islands entitled to an EEZ and continental shelf, or were they something else? So one of the questions was to invite us to provide geographic and hydrographic information, photographs, and other technical data relevant to the question that the Philippines had submitted. Now, you'll see, I think it's 9, if I'm counting properly, features that are indicated here. In the end, the tribunal actually asked us about a total of 45 or so different features and requested the same information for all 46 of those features, which was quite the undertaking, but I think shows the extent to which the tribunal took very, very seriously the responsibility to ascertain for itself the validity of the Philippines case and the validity of the Philippines evidence. So one of the things this put us to, just by way of example, was the creation of an atlas of all of the features in question. So we produced an atlas, an example of which is provided here. This is one of the features, Mischief Reef, where we tried to gather all of the cartographic, photographic, and other information available on each of the features. This is simply another page of the atlas. In the end, we ended up producing a 200-page atlas that covered all 45, 46 of these features. But this wasn't the end of the tribunal's effort to put us through our paces, if I may say. After we submitted our supplemental response in response to these questions, the tribunal subsequently bifurcated proceedings, and then before the jurisdictional hearing, submitted a list of issues that they invited us to address at the jurisdictional hearing. And then when we won on jurisdiction before the merits hearing, they did the same. They submitted another list of issues they invited us to address on the merits. And even then, we weren't done. After the merits hearings, Taiwan engaged, which occupies the largest feature in the Spratly Islands, called Ituaba, or Taiping Island, began a public charm offensive about the qualities of Ituaba Island. This postdated the merits hearings, and the tribunal even then invited us to submit yet more briefing responding to the assertions of Taiwan about the qualities of Ituaba. So you can see that the tribunal really took very, very seriously its obligation to test the Philippines, to play devil's advocate and make sure that the Philippines' assertions were in fact well-grounded in fact and law. The second point to address very briefly is one concerning questions or methods of proof. And as I'm sure most know, the central issue in the case, even more than the status of features in the South China Sea, concerned China's claim to historic rights in the entire area bounded by the so-called 9-dash line in the South China Sea. And the question that counsel for the Philippines confronted was, in particular in a situation where we knew China itself wasn't going to appear, how to go about disproving the validity of that claim. And the effort pursued several main fronts, I would say. The first was a rather exhaustive search of all of the archives that were available to us, including the archives of former colonial powers that had a presence in the region, including the archives of the United Kingdom, which of course was one historically a main navigator and surveyor of this area, and a massive survey of the historical literature on the nature of historical activities in the South China Sea, all for purposes of trying to establish that to contradict China's claim to historic rights, that in fact the South China Sea had always been an area in which, yes, China had been present to some extent, but so had the people of the Philippines, the people of Malaysia, the people of Vietnam, colonial powers. This was anything but an exclusive Chinese area of operation. Another very fertile area were maps. And this and the next point that I'm going to raise, I think, are significant because in international adjudication, from my perspective, and Judge Tomka and others can certainly comment with more credibility, but there's really one form of evidence that is probably preferred among all others. And that's evidence that could be construed as a form of admission against interest. Evidence from or by a state that tends to contradict its own position in the litigation. And Chinese historical maps were a very, very fertile area in that respect. And on the screen is just one example of a map. Now, again, China's claim was to exclusive sovereign rights on the basis of its historical activities throughout the South China Sea. But in considering that claim, if you go back and look at China's historical maps, you can find very interesting examples like the one on the screen, which is neatly captioned the Qing Empire's complete map of all under heaven. So thus, a representation of everything that China thinks is China. And if you look at it overlaid on a map of the South China Sea, you can see that it stops just south of Hainan Island and excludes virtually the entirety of the areas of the South China Sea over which China is claiming historical rights. Now, of course, questions of land sovereignty were not an issue in the case, but the point was, okay, if China, in its own mind, stops at Hainan Island, how could they possibly have historical rights substantially to the south? There were also a number of very useful statements in the diplomatic record and even in China's own legislation that were very helpfully deployed against China. So we had, for example, a 1933 memorandum from what was then the Republic of China saying that Chinese territory stops at the Paracel Islands, which are a little bit further south than Hainan Island, but not substantially so. So again, the same point. How could China possibly be validly claiming historic rights down to Malaysia if itself was stating that its own territory went no further south than the Paracels. Its own 1958 declaration on the territorial sea, it claimed two areas of internal waters, the Bohai Sea, which is near the Yellow Sea, sort of near Beijing, Tianjin, that area, and the Qingzhou Strait, which is between Hainan Island and the Leizhou Peninsula off the Chinese mainland. It notably did not claim any sort of special rights or interests anywhere else, including in the South China Sea. In fact, it recognized that the islands that it was by then claiming were separated from the mainland by high seas. So that stands in contradiction to its claim to historic rights, because if the marine areas between the mainland and the islands constitute high seas, that is open to everyone, that's inconsistent with China's claim to exclusive historic rights in that same area. So again, using China's own documents, China's own historical declarations to disprove its claim. In fact, and I'll skip the first item on the screen here, just in the interest of time, but it wasn't until the EEZ and Continental Shelf Act of 1996 that this term historic rights appeared in Chinese legislation for the first time, or excuse me, 1998. And so it was only from that point forward that China began, in a way that's still relatively nebulous, to be frank, to assert this claim to historic rights throughout the South China Sea. The final point that I'll address that was also very interesting in the South China Sea case concerned the use of experts. And this is an issue that's simmering in the cases more generally. In the pulp mills case, where Professor Kohen and I had the pleasure of working on opposite sides, there was a sustained debate about the value of party-appointed experts, party-appointed independent experts, and how much credibility, how much reliance a decision maker could really place on such opinions. In its judgment, as I say, this was an issue of some sustained debate during the pleadings. In its judgment, in its very diplomatic way, the court indicated that it didn't need to make any general statements about the reliability of such experts and could decide for itself what was true and not. By the same token, it was clear that there was and is an appropriate skepticism to the value, reliability of an expert opinion when that expert has been engaged by one of the parties for the purpose of supporting that party's case. Now, in the South China Sea arbitration, we were very mindful of the fact that China's absence put us at something of a disadvantage. We therefore made every effort consistent with the interests of the Philippines to present evidence that we felt not only supported our case, but was well-founded in scientific and legal reality. And so we presented a number of experts on various aspects of the case. You can see listed here. I don't need to recite them. But the tribunal, confronted with our expert opinions, the absence of competing expert opinions from an opposing party, took the very interesting step of appointing several of its own experts relating to a number of the issues that were in dispute. Again, you can see those experts listed on the screen, and I needn't review them, but it was a very interesting use, we thought, of the tribunal's power to appoint its own experts so that it was not in a position of relying exclusively on the one-sided presentation of the Philippines, but and at the same time allowed it to have recourse to information and opinions that wouldn't necessarily be in sort of the natural wheelhouse of a law of the sea expert, more scientifically oriented information. And in fact, the expert hydrographer rather unusually sat with the tribunal during the hearings on the merits, and I think provided very important and useful input to them. So with that, I think I'll end there, hopeful that I stayed close to time, and just say thank you very much.
Thank you very much, and you stayed exactly on time, so that's wonderful. And now we have, for the final 20 minutes, Sir Michael Wood.
Thank you very much, Fred, and let me say what a pleasure it is to be here and to thank Hélène and to thank the Luxembourg donors and to say that to be back at the Max Planck Institute here in Luxembourg is a huge pleasure. Its reputation in the field of public international law increases by the month, so far as I can see, so it's great to be back. The subject, which I can't remember if I chose it or I was told to do it, is third-party intervention, and I would add, or other third-party involvement in interstate arbitration. The starting point, I think, is that judgments of international courts and tribunals and awards of international arbitral tribunals are not binding except on the parties to the case. In addition, there's generally thought to be no system of binding precedent in international law. So one might wonder, why should third states be concerned about litigation between others? Nevertheless, they are often very interested in interstate proceedings between other states. I think third states should hire their own lawyers. That would be a very sensible thing for them to do. They could be, for example, interested in many ways, and I think also in relation to rivers and freshwater disputes as well as law of the sea. But firstly, the most obvious in the case of the law of the sea is where a third state has a claim to an area that's being delimited between two other states. This has happened in the Caribbean. One had the attempt to intervene by Honduras and Costa Rica in the Nicaragua-Colombia case. This is a well-known issue, and courts have found ways of generally avoiding encroaching upon the interests of third states. But nevertheless, there are some interesting issues which I think are not at all clear, at least not to me. One is whether a delimitation, a bilateral delimitation, establishes a kind of objective regime that is valid against the whole world in principle, unless you shout at the time and say, we don't accept this. Very interestingly, in the Ghana-Côte d'Ivoire case, the judgment on Saturday, there's a statement thrown in saying that a delimitation by an arbitral tribunal is constitutive of a boundary line. It's not declaratory. That's something new to me, and I don't know what the consequences of that are, if it's correct. But there's that issue of third states having a claim to an area that's being delimited. Another aspect could be that a third state in the same region might fear that a decision between two other states is going to set some kind of a regional precedent or establish some theory of delimitation applicable, say, in the Black Sea or in some other region, off West Africa, for example. This point was raised in the Ghana-Côte d'Ivoire case, and the court was very dismissive. It says, that's not something to be concerned about. Our award is binding only on the parties. It cannot affect the rights in any way of Benin or Togo, who were the two countries along the line, as it were. Another obvious way that third parties might be affected or might think they're affected is when a tribunal, as the Philippines-China one, is determining the status of particular maritime features. Whether something's a low tide elevation, whether it's an island, whether it's that subset of islands known as rocks, is an issue that if the court finds between two states, of course that's not binding on a third state, but it's going to be pretty influential probably. So a third state, and this certainly was the case in the case of the Philippines, China, third states were concerned at having their views known to the tribunal about the status of particular maritime features. And more widely, third states may be concerned about the general implications of decisions taken in cases to which they're not parties. My successor at the Foreign Office, Daniel Bethlehem, wrote a piece in which he suggested that all states should look at all judgments of, let's say, the International Court of Justice and comment on them. And if they didn't agree with them, they had to say so, because otherwise the law would tend to solidify in the sense that the court had given. This was a wonderfully impractical suggestion by my successor, and I don't think the Foreign Office started looking at all cases with a view to commenting on them. Even if they had the legal capacity to do that, the political downside of commenting on other people's cases would generally make it difficult. But to give an example, you have the decision in the arrest warrant case where, for the first time really, and on the basis it could be said of very little state practice, the court found that foreign ministers had full jurisdiction during their term of office. Now, if states disagreed with that, they probably ought to have said so quickly, because that quite quickly became accepted as the law, and although academics may have criticized it, I don't know of any state that criticized it. Certainly the British Foreign Secretary was quite pleased with the result when I told him about it. Now, just to skim over very quickly the kinds of ways in which states may become involved. There is the formal method, which I will turn to in a few minutes, of intervention, either intervention as a party or intervention as a non-party. But there are other ways which have been described, I think, at least I found it in my notes, as participation by a non-participating party. That's quite a nice concept. And the obvious way is to transmit some kind of a letter or submission to the tribunal, or to issue a livre blanc. And we had examples of this in the Philippines-China case. China made its position known, I think, in documents that were of which the court was aware. Vietnam submitted a very long piece. It actually tried to answer the 26 questions, I think, or it certainly made some effort to put its position before the court. So that's one way of getting your position known to the court. Another, I suppose, could be to appear as an amicus in some fashion, but that's perhaps not very likely in the case of states. Another one is to attend the proceedings if they're in public, or indeed to attend the proceedings if they're in camera, if the tribunal allows you to. And we've heard that in the Philippines-China case, that was done by quite a number of states. The United Kingdom, for example, asked to attend. I believe it didn't attend, and I've no idea why that's so. I was not advising them at the time. Another thing is simply to ask for the papers. You write to the court and you say, we're interested in this case, we'd like to receive copies of the memorials before they're made generally public. This is quite a common thing for states to do. I'm not sure, well, the purpose of it is obviously to see if they want to intervene, I suppose, to see if there are things there that should be concerning them. But it sends a kind of message, I suppose, to a tribunal if you seek copies of the papers. It shows at least you're interested. And I think at least one of the other countries did that in the Ghana case, Benin. Another is writing an article about the case, or more likely getting someone to write an article about the case. This is a way of, and nowadays, I suppose with blogs and the like, you can do it rather quickly. You don't have to wait for journals to come out in hard copy. So there are many ways of third states making their views known to tribunals. But what I would like to focus on in the remaining time is intervention in the formal sense, and in particular intervention in the case of interstate arbitral tribunals. When you first come to this, if you've been involved in arbitrations, your immediate reaction is no, there's no procedure for intervening in arbitrations. Arbitration, you have, it's the parties, it's closed, there's no procedure written down for intervention, and it really would be very surprising if intervention were allowed. I'm going to look at it particularly in the context of Annex VII arbitrations under the law of the Sea Convention. As you recall, the law of the Sea Convention has a system for peaceful settlement of disputes, for obligatory peaceful settlement of disputes, consisting of the law of the Sea Tribunal in Hamburg, the International Court of Justice, arbitration under Annex VII, and then special arbitration in particular fields under Annex VIII, which I think has never been used. But it's a system of which arbitration under Article 7 is part. And that fact is, I think, relevant to the answer to the question whether intervention is possible in the case of arbitration, interstate arbitration under Annex VII. What I would do, firstly, I think, is to point out that China, oh no, that's wrong, Professor Xianhe Yi of Wuhan University in China began with a preemptive strike on this issue by publishing a characteristically well-researched article in the Chinese Journal of International Law. This was an article that he completed, it says, in March 2015, so it was when the Philippines-China arbitration was in full swing. And Professor Xianhe Yi concluded in no uncertain terms that intervention in international proceedings is only possible with the consent of the parties in the plural, to a case, and that UNCLOS, including Annex VII, does not contain such consent. This was his conclusion, very firm. Well, I'm not so sure. I think, firstly, as we know, in the case of the International Court of Justice, in the case of the law of the Sea Tribunal, there are reasonably clear and well understood provisions in the statutes for intervention by third states, and there's case law. There's no such provision in the case of arbitration, generally, or in the case of the law of the Sea Convention, and it is indeed widely held view that intervention is not possible in interstate arbitration unless the parties expressly agree, as Professor Xianhe Yi says. And I'm not aware of any modern example of third-party intervention in interstate arbitrations. Yet, it seems to me there's no principle of arbitration that precludes third-party intervention. This was said as early as 1901 in one of the Guano cases. And in fact, the very concept of intervention was first addressed in the Hague Convention of 1899 in the context of arbitration. This was really the origin of the provisions in the Statute of the Permanent Court and the ICJ. It came from the provisions on arbitration that we find in the Hague Conventions. What I would show, and will show if we have to do something in writing, is that there are indeed at least some arguments to the effect that arbitral tribunals have the power to permit states to intervene in proceedings under Annex VII. Secondly, I think in exercising that discretionary power, assuming they have it, and in deciding whether to grant permission, a tribunal should have regard to various factors, including the good administration of justice and the need to ensure the coherence of the dispute settlement system under Part 15. It would be very odd if you could have intervention relatively easily under some of the procedures under Part 15, but not under others. Thirdly, I think in looking at the procedures that it should apply, an arbitral tribunal should be inspired by the rules that apply to ITLOS and to the ICJ. The main question then is, does an arbitral tribunal have the power under Article 7 of UNCLOS to permit intervention? I'm assuming the case where the parties have said nothing on the subject, where they have neither excluded intervention, which they could do in an agreement to go to arbitration. They could say expressly, this agreement excludes intervention by third parties, and perhaps after they've read my article they will start doing that, or they could expressly permit it. But normally the rules of procedure, which are agreed by the parties or laid down by the arbitral tribunal after consultation with the parties, say nothing at all about intervention. And what's the position there? Well, for Annex VII tribunals, you have to look for the procedural law at Annex VII of the tribunal, read in the context of the whole convention, and the various procedures that are then agreed by the tribunal. The Annex VII has a very important provision saying that unless the parties to the dispute otherwise agree, the arbitral tribunal shall determine its own procedure, And the only condition is assuring each party a full opportunity to be heard and to present its case. So, on one view anyway, Article 5 of Annex VII confers a broad power upon the tribunal to determine its own procedure. The tribunal is empowered to take any steps that it considers necessary for the good administration of justice. And the Virginia Commentary, which, as you know, was written shortly after adoption of the Convention, but which, of course, is not gospel, but nevertheless is quite useful, that does say about Article 5 of Annex 7, several consequences flow from the open-ended wording of Article 5. The rules of procedure may allow for the intervention of a third state having an interest in the settlement of the dispute. So, a very clear statement by the very learned authors of, well, of course, all authors are learned, but anyway, by the authors of the Virginia Commentary. Xian Houyi, in his article, criticizes the commentary and says why it's not, of course, of any significance. But I would go into that, but I haven't, frankly, been bothered to. Because I'm not relying on the commentary entirely. It seems to me that the really important thing is that arbitration under the law of the Sea Convention should be interpreted as a whole with the other provisions. This is a line that the Arbitral Tribunal in the Chagos Archipelago, the Chagos Marine Protected Area case, took when it was looking at the question of conflict and challenges to an arbitrator. It said, no, you shouldn't be applying special rules of conflict that apply in private arbitration, for example. This is a single system, and we're going to look at what the ICJ does and what ITLOS does, even if you don't like it, Professor Sands. Anyway, it is a system, and I think that's a strong argument for saying that a tribunal should be willing, depending on the circumstances, and it's a matter of discretion for the tribunal, to have regard to be prepared to admit of intervention. If it's felt that it can't do that in the absence of a rule of procedure, it has the power to make a rule of procedure. So a tribunal that started off with rules that don't mention arbitration could, in due course itself, if it's empowered to make rules, which they usually are, after consulting the parties, but without giving them a veto, introduce a power to allow intervention. I think time is up. So that means I cannot go into details of the South China Sea arbitration and what happened there, which I'm relieved to say because we've heard so much about that, though it did contain some interesting cases of possibility of intervention, though there was no formal request, and then other means of making one's views known. So my conclusion is that there are certainly conflicting policy considerations about the desirability of permitting intervention in arbitral tribunals. I don't think one can really generalize. I think tribunals should be quite cautious about the matter because it may go against the expectations of the parties generally. But nevertheless, in my view, it can't simply be ruled out across the board. And there are good arguments for saying that in some cases at least, arbitral tribunals, including those under Annex VII, but not limited to Annex VII, should and do have the power to admit intervention. Thank you.
Thank you very much, Michael, for a highly intriguing contribution to the debate. I'm sure this will be addressed in the next 30 minutes. I think we have roughly half an hour for discussion, comments and questions. We'll first have a first round and then see how many other people would like to take the floor. And when you ask a question or make a comment, please first identify yourself. Who would like to start with a question or comment? That's one, and two, and Arman Safario. Okay, so we have three for the first round.
Thank you, Professor Soons. I'm Lester Ortega from Guatemala. I would like to ask a question to the panel, so feel free to answer, whomever wants to answer. On third-party intervention, two ex-colonies fighting, is it wise for the ex-colonial power to participate or not? Thank you.
That's a very specific question. Then we'll first have the three ones, and then...
Sean Murphy from George Washington University. For any of the panelists, including the chair if he wishes. I'm interested on the issue of non-appearance and interested in any reflections on it in the context of a purely bilateral matter. So here I'm thinking a little bit more about a boundary river scenario as opposed to a South China Sea where there may be a number of states involved in some sense, and whether there's ever a situation where as a lawyer one would counsel in favor of non-appearance, or whether as a general matter it's always a good idea to show up argue your case as best as you can, and then let the chips fall where they will, which I suppose is another way of asking, is there any legal advantage in non-appearance after the fact where you can basically say we weren't involved in that case? But in particular interested in the bilateral versus more multilateral context, whether that makes any difference.
Clear. And then over there, Armand Savarian. And then Alan Boyle. And then we have had our first round.
Professor Murphy anticipated me to some degree. My question is also on that of default for the panel. I'd like to ask about the classification or characterization for procedural purposes of the default, i.e. what are the consequences of it for the subsequent procedure in the proceedings. International courts and tribunals have always taken the approach that it's possible for a defaulting party to end the default and return, appoint an agent and participate. We of course do not have an example of that occurring, but South China Sea, Arctic Sunrise, the door is always open. Now let's imagine that actually were to happen. Has the defaulting party, for the purposes of the earlier procedural acts and decisions that have been taken by the panel, waived or forfeited its right to express its view on that particular question? For example, third-party intervention, imagine Vietnam and South China Sea. Is it too late, as it were, to go back and reopen those questions? Or if a defaulting party ends the default and returns to the proceedings, do we start ab initio? Or can certain questions with the consent of the participating party be reopened, such as that of third-party intervention?
Thank you. Alan Boyle.
Yes, thank you very much. I think my question leads on from Sean Murphy's question. South China Sea is fascinating for a whole variety of reasons. My question, and it's one that I hope that Fred might rise to if he feels it appropriate, but also other members of the panel. Clearly, the arbitrators in the South China Sea case did take a particularly proactive approach, as Larry explained, on the questions of law and the questions of evidence. And I suppose that leads on to the obvious question, are there lessons from the procedure adopted by the Arbitral Tribunal that might be relevant to cases also where both parties do turn up? And just to point to one issue that perhaps Larry touched on it, but he didn't draw it out as fully as he might. The implications of what he was saying about all the 45 features, if I recall correctly, we went into battle originally on 7 features, or 7 or 8. And yeah, this is a case that ends up being a case about 45 features. Now, this is a very different case. It's a much bigger case, and that is, I think, unusual in international proceedings. I've only ever encountered anything comparable in the English courts. So I think there are interesting questions about whether there are any lessons here which might usefully be employed by the ICJ, by the ITLOS, by arbitral tribunals, when all of the parties are there. And just since I'm on my feet, one last quick point. I think, in a sense, what Michael said needs also to be looked at from a point which is largely not been understood or appreciated, or certainly not commented on. But one of the key features of South China Sea is that in regard to the environment, it's an erga omnes case. It's a case in which any state party to the convention could have brought the proceedings. Yes, it happened to be the Philippines, but the Philippines was not protecting its own environment. The Philippines was complaining about China failing to protect its marine environment and the marine environment of the South China Sea. And that's relevant for reasons that Marcelo mentioned, the relationship between the Watercourses Convention and UNCLOS Part 12, because you've got ecosystem protection provisions in the Watercourses Convention, and if you draw the analogy, it seems to me that some of those provisions are at least potentially of erga omnes significance, even though they relate to the domestic territory of the riparian states. Thank you.
Thanks. So while we now will hear from the three speakers in response to questions and comments made, you can also think of further questions for a second round. Shall I start with Michael?
Well, to answer the question about colonial powers, I think they should probably not seek to intervene in such a case, except in the sense that I think colonial powers often have information, documentation and the like, and it's good if they make that available, but they should make it available equally to both parties. They shouldn't be taking sides. That's certainly the attitude we used to take in London. The issue arose, I think, in Guyana, Suriname, for example. So I won't say any more about that. But in general, the dispute is between the two states. The colonial power may have information. It has a historical link to the issue, but that, I think, is not a reason for considering that its own interests are at stake and that it should therefore intervene, but it should be ready to give information if it has information in its archives or allow access to its archives. And I'll just say a word about Sean's question. Is there any legal advantage? Could you advise ever that there's a legal advantage in non-appearance? I think non-appearance is largely a political decision. It's sometimes thought that if you don't appear, it's easier then to reject the decision. But of course, the decision is legally binding, so you can't, in law anyway, reject the decision. It may be politically easier to stand back from the decision. My own view is that however much you dislike being dragged before a court, it's much better to participate, even if you think you're going to lose, because you'll probably lose less badly if you participate and behave very reasonably before the court. Of course, there's a halfway house. One can do what the United States did in Nicaragua and participate in the jurisdictional phase and not in the rest. Israel also, in the Wall case, participated to deny jurisdiction, but then not in the rest. I think my advice would always be that this is a mistake. You are going to do better, even if you lose, by participating and being reasonable and arguing your case before the court than by standing aside from it. Thank you.
No further observations on other questions, like, for instance, how do you classify the several steps of non-appearing as waivers, for instance, what the implications would be? I think that was Armin Savarian's question.
Yeah, I'd just make one comment on Alan Boyle's question. I talked about third-party states, essentially. But of course, there could be third-party international organizations, the European Union, but also, for example, the Seabed Authority might have an interest in some cases, which might affect the area. I don't want to encourage that too much, but nevertheless, that's an interesting case. In a sense, the international community of states, or without of states, as a whole, might have an interest, but then that's hardly a person who can hire a lawyer to appear. But there is this general erga omnes issues that can arise, which might lead to some quite interesting interventions. Thank you.
Mr. Martin, some responses, reactions to questions raised.
Sure. Beginning with Sean's question on non-appearance, observation, I guess, about China's non-appearance. I'm not sure what I would have advised them had I been their lawyer, but had I been Xi Jinping, I probably would have made the same choice not to appear, because the consequence of China appearing in the case would have been, by necessity, to articulate exactly what its claim and position is in the South China Sea. And as a matter of geopolitics, their policy had been one of strategic ambiguity. And maintaining that strategic ambiguity required them not to participate. So as a lawyer, I'm not quite sure what position I would have taken, but as a leader of China, I think that really was the only decision they could possibly have made, although it certainly didn't work to their advantage. It has enabled them to maintain this policy even now of strategic ambiguity, although it's getting less and less ambiguous as we move across time. On the procedural questions about non-appearance that were raised, I'd certainly defer to you, but I would note that one of the points that the tribunal emphasized frequently, and a balance they are at pains to strike, was to leave the door open for China to appear at any time, but by the same token, make sure that the other party, in this case the Philippines, was not prejudiced by China's non-appearance. And part of not prejudicing the Philippines entailed maintaining the timeline on a reasonable basis. So I think if China had appeared, things that had been decided, I would imagine, would have been left decided. So if intervention had been permitted, I would imagine, just as a matter of what we in the US call law of the case, that decision would be left in place, but without prejudice to future decisions that had been yet to be made, including on the merits. At every stage, not just at the point where China failed to submit a counter memorial, at every stage the tribunal was at pains to say, if China wants to say anything about this, it has until X date. So the door was always there, and I think substantively everything would have been left undecided until the very end. So I don't know whether you, Professor Soons, want to add any other observations.
Let's first hear from Marcelo Kohen on some of these issues.
Well, first, just to complete the answer by Sir Michael to Lester Ortega, I'm not French, but I also know that France adopts the same attitude when there is a dispute between two former French colonies concerning the boundary dispute. If one of the parties seeks information from France, France gives the information to both sides. With regard to the question raised by Jean about advising non-appearance or not, my definite answer is I would not advise non-appearance. And for a number of reasons, and not just because I am a lawyer and I'm thinking about specific interests or with our narrow-minded legal perceptions, but think about the following. Following what Larry said, is China better off now, after the award rendered by the Arbitral Tribunal, due to the fact that it didn't appear, or not? My answer is, I don't think China is better off right now because of its non-appearance. So you have a decision. I would even say that the Philippines is in a better position now to negotiate with a big power like China. And sooner or later, China will have to negotiate with its neighbors in the South China Sea. And you always have something to say before a tribunal, and the tribunal is always ready to hear you. And probably, if China would have appeared, maybe some decisions would have been different. And the same is valid for ICJ. And I would add, not only in contentious cases, but also in advisory proceedings. I had in mind, in particular, the construction of a world advisory opinion. And I will not extend on that because this is not related to international waterways, although, or the law of the sea. On the contrary, if the question would have been, would you advise intervention? My answer would be completely different. I would say, think it twice, even more, 3 times, 4 times, 5 times, before going to the court or a tribunal for intervention, because what you have to win is limited. What you have to lose is quite extensive, I would say, in general. But with regard to the other questions that were raised, decisions having erga omnes effect, etc., I believe on the wisdom of the system. Article 59, 60 of the Statute of the ICJ and similar rules in UNCLOS. The judgment or the award is only binding between the parties and for the specific case. I would say, hypothetically, nothing prevents Malaysia or Vietnam to disagree with the findings of the arbitral tribunal in the Philippines-China case. Nothing prevents. And this is the wisdom of the system, because third states cannot prevent 2 states willing to settle a dispute, but at the same time, they are not bound by the decision of the court of the tribunal. And I think this is the wise manner to solve or to see the things.
You can keep that. I have my own. I will refrain from commenting and certainly from speculating on how the tribunal would have dealt with the situation of a subsequent entering into the proceedings. We have now had the experience of 2 Annex VII Arbitral Tribunals with a non-appearing party. You will, if you look very careful at the rules of procedure, you will see some dissimilar treatment, for instance, in the procedure of the sequence of pleadings. In the South China Sea case, equal time was another system followed in the Arctic Sunrise case, where the tribunal in the rules of procedure gave the opposing party a limited period of time within which it could indicate if it would was intending to submit pleadings. If not, then the proceeding would continue, and that, of course, limited significantly the length of the proceedings in Arctic Sunrise as compared to South China Sea. But let's now first look at other. Let's see, one question. Oh, no. Now I have 7, 8 questions. We start at the back, and then, yes?
Thank you. Angela Ha, Volterra Vieta. Thank you, Sir Michael, for setting out the principled basis why third-party intervention should be possible in interstate arbitration. I'm curious about, I can imagine situations where a party to an interstate arbitration may wish to oppose third-party intervention. If they do, what might be the legal arguments they use to do that?
Okay, that was a question. Then I have here yeah, you already have the microphone.
Yeah, Sam Wordsworth. Okay, the question really, again, for Sir Michael is how persuasive he thinks the Chagos Tribunal reasoning was in that aspect of the challenge decision. Because couldn't it just as easily be thought that the states, once they've elected for arbitration under Part 15, are actually wanting something rather different to application of the usual rules under ITLOS or under the ICJ? And sure, one can see that maybe Mauritius was pushing things a bit too far in seeking application of the IBA rules on conflicts in international commercial arbitrations. But nonetheless, states may be expecting so far as concerns their international arbitration, something different to the usual rule on third-party intervention.
Okay, while the microphone, I think Erik Franks asked for the floor, and then there was also over there. You have a microphone. Go.
Thank you, Erik Franks from the Vrije Universiteit Brussel. We were told that today judges and arbitrators very often receive all these kind of documents which are not the normal, which do not follow the normal way. You have position papers, you have parties who are not intervening but sending letters to the tribunal. All these papers, they do influence the arbitrators and the judges. Isn't there, and that's my question, isn't there a problem of transparency? Because very often these documents are not published, right? They do not form part of the official documents of the case. Thank you.
Peter Tomka also, but first you have a microphone already, I think, yes. And then Peter Tomka, and then Tulio Treves.
Thank you. Vladislav Lanovoi. My question goes to all the speakers. I have an impression that there is a common thread going through all of your presentations, and that is that while we have Article 59 and while we have a strong sort of absence of stare decisis in international law as concerns issues of substance, of substantive law, applicable law, we seem to be witnessing nonetheless some procedural convergence, and the point made by Professor Kohen proves there too, except for maybe provisional measures where there is a little bit of discontinuity, for example, if you compare ITLOS and ICJ. But I wonder in all other points like non-appearance, like third-party intervention, or the approach to expert evidence, there seems to be some kind of convergence process, and I would like to hear your views. And so I guess the question goes slightly in a different direction from Mr. Wordsworth one. Thank you.
Thank you very much, Peter Tomka from the principal judicial organ of the United Nations. I have a comment, but maybe a mise au point, and then a question. First is about the non-appearance, whether to advise or not. Experience shows, and I'm speaking about the experience in International Court of Justice, because that court faced a couple of cases of non-appearance in the 70s and early 80s, that in all cases of non-appearance, except one, the non-appearing party at the end was so-called losing party. That was in the case of fisheries jurisdiction, Germany and UK, 2 cases against Iceland. That was the first non-appearance. Then you had the case of Greece versus Turkey, AGNC. That was the only case when the non-appearing state was happy with the outcome, the court coming to the conclusion of being without jurisdiction. But then Islamic Republic and the Tehran hostages did not appear, and clearly the court ruled that there was a breach. United States, it was first appearance, then non-appearance, and at the end merits were not in US favor. Luckily, since that, there was no non-appearance, and here I would a little bit disagree with Sir Michael, because I don't think that Israel could be qualified as non-appearing party. Israel participated in the written phase of the advisory proceedings, limiting its submissions to issues of discretion or whether the court should render advisory opinion. A number of states which submitted written statements have not then availed themselves opportunity to present arguments orally, so that was certainly not a case of non-appearance. Similarly, I think one cannot qualify Pakistan as non-appearing in the Marshall Islands cases because Pakistan submitted written pleadings and just sent a letter that they don't think that they would have something useful to add what they have written in the written submissions, so they have not availed themselves opportunity to present arguments orally. And maybe Pakistan was then satisfied with the outcome, although I understand that majority of scholars certainly not. So there were just a few cases of non-appearance, but as I said, only in one, the non-appearing party was satisfied with the outcome. And in relation to arbitration, which was so much highlighted by this panel, I think there was still option, first to challenge jurisdiction, in a very effective way, and then depending on the outcome to decide whether to continue or not. But here I come to the question, because my feeling is that in addition to a book which was published and edited by Stefan Talmon and Bimbing Jia, in which some arguments and positions were elaborated on, then ambassador of People's Republic of China, not writing to the tribunal, but to individual members, I think submitted some papers. So I think the tribunal members might have been aware of certain arguments or position of People's Republic of China, although China formally has never recognized the tribunal, and that was, I think, the way of communication. But I may be wrong, but since several people here in the room are present here, participated in those proceedings, I would wish to have a clarification whether that was a way of communicating certain views and positions. And I thank you.
Thank you. I think Tulio Treves, and then that is the last intervention, and then we have a very short final response from the three members of the panel.
I'll just make 2 or 3 very short points or questions. First, Marcelo, in his intervention, spoke about the Article 283, which does not provide indeed for exhaustion of diplomatic means. My question is, doesn't he think that the reading or the interpretation by the tribunal errs on the opposite side? It practically destroys the requirement, especially if you look at the Luisa case, what kind of exchanges were there, I wonder. Another point, well, of course, about non-participation by China. I think there is also another element to be taken into consideration, the cultural element. To go to court in the Orient is something you don't do. And you could see also the reluctance of Japan to be involved in cases. And then it was involved, it could take an opportunity in the southern bluefin tuna. It could even exploit the prompt release mechanism, and it became a custom to go to court. I think I share Larry's position. If I had been the head of China, I would have taken the same decision. How can a country that by culture is accustomed not to go to court start its experience with courts with such a huge case involving security, territory, sovereignty, and all you want to add to it? I think it was to pretend too much to think that China would appear in that case. Even though I may agree with Marcelo, they might be better off had they appeared. And then a point made, I think, by in a previous intervention, the papers coming irritually to the court or tribunal. Well, we had some experience in the seabed dispute chamber of papers coming from NGOs and so on, and the decision we took was to deny participation to the hearing because there was no basis for that. But we accepted not to put in the file their submissions, but to put them on the website, which in modern times is very close. Thank you.
Thanks. Just opportunity now for very short responses by the three members of the panel, and I'll start with you.
Yeah, there are many things. So we have to choose some of them, not all of them. The question of the cultural attitude of non-appearance, because in the tradition of some states, in the history of some states, they they didn't like arbitration or the international judiciary. That was the case of China, that was the case of Russia. It is interesting to compare the situation of China or even Russia in the Arctic Sunrise with the attitude of China before the ICJ in Georgia versus Russia. So Russia decided to participate, and at the end of the day, it was happy with the outcome. So that's an interesting point, and maybe this cultural attitude may change, or some Pavlovian attitudes. Concerning documents that reach a tribunal or the court through informal manners, if they come from the parties, from the party that decided not to appear, or if they come from third states, the situation is different with those documents coming from NGOs or individuals even. So we live in an era in which documents circulate in a very easy manner, and the court or the tribunals accept documents that are in the public domain, invoked by the parties, even at late stages in some cases. So I think that the court or the tribunal, while accepting this documentation, insofar as it is communicated to the other side, which is always the case for obvious reasons, I don't see any problem in accepting this kind of documentation, and there is, even though it's not following the formalities. With regard to the exchange of views, well, I believe that this condition is difficult to be denied as being accomplished. And tribunals find very easily that this condition has been met. So that, and it's quite reasonable, because if you have a party that is willing to go to the tribunal to find a settlement of a dispute, just not to do it because of a narrow interpretation of the condition of exchange of views, I don't believe this would be wise.
Okay, thank you. Yeah, great. Mr. Martin? And then Mr. Michael Wood.
Mindful of the time, I'll be very, very quick. First, with respect to China's position paper, it wasn't just submitted to the tribunal, it was posted on the Chinese Ministry of Foreign Affairs website, so there was no question of lack of transparency there. They were very vocal about it, and practically, I think it was a huge mistake for China, but a great help to the tribunal, this is my surmise, by allowing the tribunal to know what the heart of China's arguments were and what were more extraneous arguments, so that the tribunal was able to focus on what China was really arguing and destroy those arguments, because honestly, they were very poor arguments. On the question of China's loss or not, if I may make a provocative statement in partial response to Judge Tomka's, China lost on the law for sure, but I think history remains to be written as to whether it merely lost the battle and won the war in the long run. I think there's a case to be made that it is currently winning the long-term war beyond the case. I'll stop there.
Okay, in response to the question about what arguments a party to an arbitration might put forward to oppose third-party intervention, I think it's fairly obvious. Firstly, they could argue that the arbitral tribunal has no power to allow the third-party intervention, and then in the alternative, they could use the same kind of arguments that you use in ordinary intervention at the ICJ, that there's no interest, there's no need, that the discretion should be exercised one way. Then second and last, in response to Sam Wordsworth's very good point that arbitration is different, that's why parties choose it. I would say firstly, they don't always choose it under UNCLOS. It's compulsory under UNCLOS. You may have chosen ITLOS or ICJ, but you have to go to arbitration because it's a fallback. So only one party's chosen it. But I think the reason why it's a fallback is because people insisted at the conference, particularly the French. They did not want a pre-constituted tribunal to be compulsory. Monsieur de la Charrière used to go around saying pré-constitué, c'est mal constitué. So arbitration turned up. But that's the chief reason. It's because you can choose the members that some people prefer arbitration. There are other differences, and one very important one that's often overlooked, I think, is the question of bifurcation. If there's a challenge to jurisdiction and admissibility before the tribunal or the ICJ, automatically the proceedings are suspended while that issue is decided. That's not the case automatically with arbitration. It depends on the rules, it depends on what the arbitral tribunal decides. In the Chagos case, of course, the tribunal, after a day-long hearing as to whether it should bifurcate or not, decided not to without giving any reasons, which is interesting. And so jurisdiction was wrapped up with substance. Thank you.
Thank you very much. Well, it's obvious that we could continue for hours discussing the points that have been raised and also the points that have not yet been raised or not been raised. But we have to end. We will hear in a moment how much time we will have left for coffee. I hope enough to just get at least a cup of coffee. But 20 minutes at the most for the coffee. But let's first thank the three panelists for their excellent presentation.